The Supreme Court also heard oral arguments in a landmark First Amendment case. The lawsuit filed by the states of Missouri and Louisiana alleges that the Biden administration officials coerced platforms to censor content. During the hearing, conservative justices expressed skepticism that a line had been crossed. The White House says officials are entitled to share accurate information on public health and elections. No evidence was ever presented by prosecutors that any action was threatened by government officials against any social media businesses. For more, let's go to David Greene. He's a senior staff attorney and civil liberties director at the Electronic Frontier Foundation. Great to have you on the program. Thanks for joining us today. Tell us more about the arguments made today.
So the arguments focused on what is the line that separates permissible government communications to social media platforms from impermissible communications, and the various parties offered their different interpretations of what that test should be. The government thought that the court should really look at what we call a coercion analysis, where what we're seeing is that the government is threatening some type of adverse action if a social media platform does not remove a specific post or de-emphasize it or moderate it in some negative way. What the states and the individuals who sued were saying is that it's not just coercion, but this concept called encouragement counts as well. And the lawyer who was representing them even said that he thought that any specific ask that even if it was just a request or we think this should be taken down, that would cross the line. So that's really what the court has to figure out.
Can you talk a little bit about the evidence used? There's been accusations that snippets of various communications between the government, social media executives and other parties appear to be stitched together or manufactured. Is that your understanding? Is it possible that justices could be led astray on the basis of disinformation?
Well, so the factual record in this case is enormous. It's almost 20,000 pages. So that's really exceptional for a factual record that would come before the Supreme Court. And actually, the trial court that looked at it took a year to go through it. And so I have not read all 20,000 pages, but there has been a lot of reporting from those who have either looked at the whole thing or looked at specific parts and said that it's the courts below drew conclusions that weren't supported, that the timeline has been manipulated, things like that. It'll be interesting to see how the court handles this, because under one version of this case, the Supreme Court will actually be required to conduct its own independent factual review of the record, and they actually have to decide these cases by the end of June. I don't know if they have time to.
It seems one big question is how, if some of these claims are actually factually false, how then they actually brought misinformation to the country's highest court.
Yeah, it's how it gets there is an interesting thing. And again, I don't know one way or the other whether or not some things are true or false. In the brief, a friend of a court brief we filed, we pointed out a few examples where we disagreed with the lower court's application of the law to certain facts. So whether things are false or just presented confused, I think the fault might more lie with the factual determinations made by the lower courts than with how it may be presented.
Okay. As we round it out, we're running out of time. For our international audience, could you just explain, is this an attempt from Republicans to make disinformation the status quo online? And what could that mean for the elections, given that it is an election year?
I don't think it's that broad, and I actually think you saw that concern by the justices across the court, regardless of ideology, thinking that there are really very appropriate times for the government to say something. So I don't think it's an effort to make disinformation. Those who brought this case were really focused on a few very specific things, one being COVID vaccine hesitancy, which the Biden administration targeted, as well as what they should be foreign election interference. And then there was also a bit about sort of Hunter Biden's laptop and things like that. So they weren't looking at disinformation broadly. They were picking things that they thought that the Biden administration had made a special effort to challenge. But again, as I think you're saying, is that once you establish the rule of law, it's going to apply regardless of the subject.
All right, David Greene, thank you for your insight. Really appreciate your time.
Thank you.